Well, thank you, Caroline, for being here. Why don't you introduce yourself a little bit? Tell us about your business and what you do.
Sure thing. Okay, so by day, I am a intellectual property and corporate law attorney, which means I do trademarks, copyrights, contracts, corporate formations, and I do work with some startups. And most of my clients are like under that $5 million mark. So, um, smaller companies, uh, but I am lucky enough to work with a couple larger companies on their IP portfolios, so just protecting their stuff.
Mm.
And by nights, weekends, whatever, I run the Engage Legal Collective, which is a um, template and uh, informational shop, kind of like blog and informational resource for wedding and event professionals. So basically, just trying to help y'all figure out the legal part of what's going on in the industry.
Why did you decide to go weddings and events versus real estate or
Yeah, that's a great question. So I started my law practice when I was 24 years old. 25. I graduated law school at 24. I went up to New York for a little bit, was like, not my fave. I was in media, and advertising, and I was working at Sony Music, um, in their in-house legal. And I was just like, you know what? I'd rather do exactly what I want to do, work with exactly who I want to work with. And so, that coupled with a little bit of just naivety and being young and dumb and broke and not having any responsibilities, I was like, I'm just going to go back down to Virginia where I went to law school and open up a law practice. So I did. And I originally had wanted to work with music industry folks and advertisers and really work in kind of like as an inside counsel for advertising agencies. But when you're 24, 25, not a
yeah.
lot of people are going to trust you with their millions of dollars of ad revenue and $1 million agency. So I was very lucky to kind of get in with a lot of the creative individuals in Richmond. And a lot of those folks were your wedding and event professionals that are industry leaders today. So a lot of those folks, I worked with for a while and they kind of blew up and needed the help. And so ever since then, I was very much into the creative and wedding and events world. As a lot of young women really enjoy that.
Yeah.
So ever since then, it's been just kind of a spot where it helped me launch my career. And so I want to always make sure that I'm providing value and information and resources to that community that helped me get where I wanted to be.
All right. So with our group, we have a lot of newer wedding planners, people who are inspired and want to start a business. And I've noticed that there's a lot of ladies there that are asking for contracts. And what is the good, bad, and ugly of that whole situation?
Well, the first thing you have to think about is, okay, I'm using this person's contract. How do I know that where they got it was a good resource? You always want to be able to vet your resource providers to see if they know what they're talking about, if they're within the industry, if they're outside of the industry, because events, especially, there's so many different things to think about that if you're not familiar with the industry, you may not cover all those bases. The second thing to think about is, does this apply to my state or was this drafted with my state in mind? If you're getting a contract that was drafted specifically for somebody by their lawyer, maybe, um, they may be in a different state than you. There might be some considerations that are enforceable in one state, but aren't enforceable in another state. So that can cause some problems or some issues where maybe you're hiring an independent contractor or you're bringing on an independent contractor to help with a project. If you have a non-compete in that independent contractor agreement, because maybe that's okay in whatever state the person got the independent contract agreement from, or maybe it was okay last year or 2 years ago, and maybe it's not okay now, this is a big Virginia issue right now. And there's either a non-compete or some sort of restrictive a
Language.
restriction.
Yeah.
Now, if you give that to an independent contractor, you could be fined $10,000 for including that in the independent contractor agreement. That's something we're
Wow.
dealing with in Virginia with, that's actually employment agreements as well in Virginia, which is kind of that was a big shock to everybody. So, you could also be misclassifying things and get fined by the Department of Labor for those kind of violations. So those are the things you want to think about state by state or even year to year, just because things do really change.
Mm-hmm.
Another thing to think about is that person may have probably and hopefully edited the contract to fit their business. It may fit their business structure. It may fit their business style, and that might not fit yours. There is no one way to run a business or to structure a business or to there's no one perfect way for everyone that puts everyone on the same, path. If that was true, it would be very easy to start businesses and everyone would do it and it wouldn't be hard. But as we know, it's not super easy. It's simple enough, but to actually succeed, it can be tricky, and you need resources and you need people in your corner and people telling you what to do and what not to do, as I'm sure Valerie's helped you out with. So they have probably edited that contract, and you don't know what edits are made for them versus what can be edited versus what can't. So
That's a good
I
point.
think starting with the clean slate is the best option. And finally, if they are getting it from someone a template instead of a lawyer, like, so I have my law firm and then I have my Engage Legal template store, and those are two different entities. And while a lawyer's contract, maybe that's not copyrighted or we haven't done anything special for that, the templates that are outside of my law practice that are offered through Engage Legal, those are, it's not a lawyer client relationship. And so those are just like any other resource on the internet, those are copyrighted. So sharing those copyrighted materials could be a copyright law violation. So there's just a lot of different things to think about. So it's probably not, from either perspective, whether it's coming from a lawyer drafted for that person in a specific state, etc., or it's, a template that might be copyrighted. It's not from a lawyer, but it's probably copyrighted to whatever organization. Both of those options kind of make it a little bit like, contract sharing might not be the best idea from any perspective.
So yeah, with you provide templates, and then what's the best way, I guess, to get that legal, right? You have a template and then you take it to an attorney in your state, or
the reason that I started offering templates was because I knew that there was a gap between like what I could charge as an attorney to be profitable versus what people starting out could pay for a contract. Like, to book me to do a contract, the minimum I can charge and still be profitable is $600. And that's just for like your basic, that's not true. $450 for an independent contractor agreement, but that's because I have it like literally down to a science. But anything else, I have things that I have to hit to be a profitable business. Then there's people starting off and you probably can't pay more than $200, $300 for a contract template. So there's a big gap, right? And my templates and most folks' templates, and most people will agree to this, the templates are meant to get you through to a place where you can have something custom done for you and that really reflects you and have somebody really go through it and work through it with you and really need through it. So what I would advise everyone to do is, get your template, use it, but whenever you can and at your earliest convenience, at your earliest time that makes sense, get it reviewed by a lawyer. Get it reviewed by a lawyer in your state, any state that you're working generally, or that you're doing business repeatedly. Like I am in the DMV area, the Virginia, Maryland, DC, and even Delaware. We'll throw Delaware in there. You're often bouncing around from state to state because we're all so close. On the East Coast, we are mushed, unlike West Coast where they're all spread out. So people will do weddings in all those states. So I would get it reviewed by a lawyer that is licensed in those areas, or at least knows the laws of those general jurisdictions, because like I said, different things in different states can pass. Other states they won't. Sometimes if there's something in a paragraph or a section of a contract that is like considered not enforceable, they will literally just axe the whole section. Like they won't even like try to redraft it. They'll just be like, nope, wrong, bye. So that's why it can be really important to get that looked at.
All right. Speaking of contracts, what type of contract should newer wedding planners consider getting?
Absolutely. So what I would say is and I get pushback for this, but any lawyer is going to tell you, you need a contract that covers everything. There is a lot of there's a lot of concern, I guess, over, okay, well, this contract's like 10 pages long and it's going to scare off my clients, blah, blah. And here's what I'm going to say to that. So first off, you always want to make sure you're covered. There is a balance between like scary language versus wedding planner language. There just is. There's always going to be. And so when I draft a wedding planner agreement, that's going to be very different than a corporate events planner agreement. They're just going to be different. Are they going to be the same clauses generally? Yeah, they're gonna probably cover mostly the same stuff. Corporate events planners are probably going to deal a lot more with like, there's going to be more money considerations about stuff like going where it goes, whatever. But generally speaking, 8 out of 10 clauses are going to be the same. So you can make it so it's not scary, but it still covers all the things it needs to cover. So that's what you need to look for. Also, I have never seen an event planner agreement shorter than 6 pages that covers what it needs to cover.
Yeah.
And like, that's with tiny text. So I really think it's going to need to be longer, because what you guys do is so comprehensive and there is so much risk. And if something goes wrong, it's going to be y'all's fault. Like, it's just going to be your fault.
Right.
I mean, that's just the way it is. So kind of looking to that, you need to think about, okay, where are all the, if you're trying to evaluate, all right, well, is this what I need to have? Like, does this cover everything I need to cover? Think about all the worst case scenarios you've ever heard of. I'm the most positive worst case scenario person you'll ever meet, by the way. But you need to think through like, okay, we are planning for the zombie apocalypse when my clients lose their minds and just completely go nutso. Because in the beginning of the relationship, obviously you're not entering into a relationship with somebody you think is going to like blast you on Facebook or like be a nightmare, but then you always end up and you're like, how did we get here? Like, how did we end up here? So you're going to want to think through, all right, what are all the worst case scenarios that could happen? What are all the things that could go wrong with the way that I offer my services? Do I do just, well, we know day of is a myth, like it's not a real thing, but am I just showing up there and they're expecting me to like assemble favors and like do all this stuff? Like, we need to make sure this
Building
is all in the contract.
arches.
Yeah. Like, am I going to be in charge, like make massive installations? Like, I'm not an event designer, I'm literally just here to like coordinate things, but like, do your clients understand that? So making sure all those expectations are in the contract, and then exactly what you're doing. And we had talked before we jumped on about freebie, like, do I have a freebie download? And my freebie download is really like, okay, does your scope of work align with what you do? And you need to think through who, what, when, where, why, how many, how much. And those are kind of the journalism. If you ever went to like journalism school or comm school or like took a journalism class, you need to be asking as many questions off of those WHs as you can. Who are you serving? Who is the client? That's actually sometimes a harder question than you think
That
it's going to
is a
be.
hard
Like,
question. Yeah. Is
especially,
it
and
the
if you're
one?
doing East Asian weddings, like typically the parents are going to be a lot more involved and they might be a client. Whereas typically Western weddings, you're going to see more the clients are the couple themselves. So, maybe you're working on an East Asian wedding and the client is the bride and the father of the bride. And that can be culturally more acceptable and more typical than if you're just working in a Western wedding where, like I just said, it's typically the bride and the groom together. So who's a client, who can make changes to the agreement, who can sign for the couple, who can like accept things for the couple on the day of, who's going to be their point person. If stuff goes wrong, you don't want to bother the couple, that kind of information. What services are you providing them? Like, exactly what are you providing? Not like, I'm going to provide wedding planner services.
What is that?
What is that? Like last time I checked, that wasn't defined by law. Like that's not like written into law anywhere. So you have to pretend like you're explaining to an old white guy who doesn't understand what's going on. Like he literally just signed a check for his daughter's wedding and like went on his merry way. So you need to say like, I will be answering phones between this time and this time. I will be coordinating your rehearsal dinner. I will be coordinating the rehearsal itself. I will be providing mock-ups. I will be providing 3 mood boards. You pick one and then we move forward with that one. We don't combine all 3 of them together and like so that kind of stuff you need to just like work through. And a way to do that is if you are and Valerie, you may be working with this on this with them, but like once you figure out your process, so figure out your process and then like write it into your contract, write your contract based on your process. And your contract should take your customer, your client through their journey with you. So it shouldn't be like fees up front, termination up front. Here's what I give you. This is how we do our mood boards, blah, 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 blah. Because no, you should like take them through like, here's how you book with us. You don't get we don't reserve your time until you pay this non-refundable reservation fee or non-refundable retainer fee. Then your payments are due like this, this, and this. Then, if you redo our meetings like this. So it needs to really take your customer through their journey because it's also an extension of your brand.
Right.
So when you are working on your contract or looking at your contract or redrafting a contract to fit your business, make sure it matches your brand, your process, and all that. And then finally, one of the things that I think a lot of people don't think about is there needs to be that fine print at the end that nobody really reads. And, it's like on all your credit card statements and you just kind of like glance over it because it's like this big. But those are actually extremely, extremely important. And we've kind of been conditioned to ignore them because we don't understand them. We were never taught to read them. It's a ton of legalese that we're just like, whatever, cool, or okay, bye. But it contains things like where you can be sued. Where do you want to be sued? Do you want to be sued on your home turf? Because you can decide that. You can decide all this in advance. Do you want to have them go to mediation first? Sometimes mediation can be helpful. Other times, if you're just entering the market and you are $1,500 or below for your wedding plan, or maybe even $2,500 or below for your wedding and event planning, having a mediation doesn't necessarily make sense if you need to recover fees or whatever, because that's your entire fee is going to be sucked up on mediation and legal fees and paying a mediator.
Wow.
So you really need to look at, okay, well, like, do I really want to have a mediator? I will say this, 99% of the time, you do not need an arbitration clause. You do not want to have an arbitration clause because that is as expensive as legal. And
that's really interesting because
yeah,
all the contracts I've seen have that. And I think mine actually.
yeah, and it might. And a lot of people are like, oh, arbitration, it's so great. But it's a good method for you to use if there are a ton of, like for my tech companies, arbitration, yeah, we want to do that. We don't want our trade secrets spilled out to the universe. We don't want our product design spilled out into the universe. But if you are a event planner and you're trying to collect fees, or they're trying to say like, oh no, we want our money back. We want $100 back. We're going to sue you, or $500 back. We're going to sue you, blah, blah, blah. Going through mandated arbitration is going to be thousands of dollars.
Wow.
Whereas depending on your state, you may be able to utilize small claims court. In Virginia, it's under $5,000. Texas, I think, is like under $10,000. Usually it's 25, 15, 10, or 5. And you can utilize that instead of having to go through arbitration to recover money. Whereas to do a small claims court, it's no lawyers. You just file a warrant in debt, you're in and out. You have like a 1-day thing. You bring your documentation, you bring your contracts, the judge makes a ruling. Cool.
Very nice. So new wedding planners coming in, what kind of contracts do they want?
Always you need to have your contract between you and the clients. Like always, we need it.
That's your event planning agreement. Is
Your
that?
event planning agreement,
Yeah.
just straight up. Sometimes you'll hear it referred to as an MSA. And if you hear the word MSA, that just means master service agreement. Like, sometimes even I'll like slip up sometimes, be like, oh, this is in your MSA. I mean, your event service agreement or your wedding planner agreement or whatever. MSA just means like your overarching agreement. Cool. And then that needs to have, things like your scope of services, your fee schedule, what's refundable, exactly what's not refundable, what happens if they want to postpone, what happens if they have to postpone now post COVID. We know how important that is, and under what circumstances they can postpone without a fee if that's something that you want to do. If it's not, that's fine too. And then terminations, what that looks like, what money goes where, when that goes where, that kind of thing.
Yeah.
And those are just some of the big flashing lights, like you must have this before you can move forward, or you do not pass go and do not collect $200. So those are the kind of things that you need to be looking at. And then the next thing I would say is having a third party payer agreement can be very important. If the couple themselves are not paying for these services and someone else is paying for it, and they don't sign the contract and they pay for your fees, they technically didn't agree to the non-refundable X dollar retainer. They didn't agree to the postponement clauses and the termination and when things are refundable and when things aren't. So it's going to be really difficult to say like, oh no, like they signed this agreement or they're bound to this agreement, because unless they sign an agreement saying, yes, I agree to the terms of the master service agreement or the event planning agreement, and I agree that these are non-refundable, you really can't hold them to that. So that's, I think, your next really big, important agreement to kind of get on the books. Also, I would say make sure you have a copyright transfer agreement to use with photographers, because even though you're the one that put everything together and like made it look really pretty and like probably designed all this stuff and put together the mood board and yada yada, the photographer is the one that clicks the button. So the photographs that the photographer has of your work, they technically belong to the photographer. So in order to use those images, you have to get a copyright transfer, a copyright license. This would probably be a license. So you would need a license agreement, which means you have the ability to use these pictures on your commercial website. Easy peasy. That means you would have to go directly to the photographer. Just giving credit is not a license. So you can't just be like, oh, I used these off of this photographer's Instagram, but I gave them credit, so it's okay. That's not how it works. I have gotten thousands of dollars for photographers because like some corporate entity was like, we're just going to use these off their Instagram and put it on our website, and we're like, no, you can't do that. Like, pay my photographers, please. So most corporations have at least learned this, but when you're starting out, that's kind of what you just think. You think like, oh, I give them credit, so it's fine. Give them a link, tag them in Instagram. It's not okay, because you're using it for a commercial purpose. It means on your business Instagram, your business blog, your business website, your business Twitter, your business Facebook, whatever. There are companies who, if you use pictures off the internet, they have software that literally just scrapes the internet to find those photos. And then they go through and demand a couple $1,000s of a licensing fee, or they will sue you. So for sure, don't use pictures like straight off of Google.
Right.
Just because it's on Google doesn't mean you can use it. Make sure you're using royalty-free stock photos or licensed photos, anything like.
Well, then going along the lines of the photographer, a like styled shoot contract.
Yes.
Is it the photographer who should have that, or the planner who should have that? Who's usually?
I think whoever's organizing it needs to be in charge of it, honestly. But if you are somebody who goes to them frequently, like having one in your toolkit is probably good. Typically, unless you are, so the style shoot contract that we have on our website, it's more of a collaborative one where it's like, okay, this is what you're bringing, this is what you're bringing, this is what I'm bringing, blah, blah, blah. However, if you are somebody who stages style shoot contracts to, invest all the money, does bring on the different vendors, but like I know that there are people who do that. You need to be the one offering that contract. And you can also be a bit more restrictive with it as well. Like if you want to make sure that you are the one that's allowed to submit to industry blogs, like we're kind of seeing that a little bit more. now trend wise, where it's less of like the collaborative and more like, I am organizing this style shoot. If you would like to be a part of it, here are the parameters. Here's what, we're offering. Here's what you can do. Here's the exclusivity on it, that kind of thing. So that would be more of a style shoot and if you're charging people too, especially to be part of a styled shoot, you need to be the one that's offering that contract to them as well.
I know some wedding planners like to review contracts of other vendors. I never did that because I was more on the event management side of things. And so I was like, unless they wanted me to. But is there anything they should be looking out for if their client would like that? Or
yeah. So what I would say is, first off, you need to make sure you're telling them like you're not a legal professional, because if you are saying like, oh yeah, we can review your contracts, there's a blurred line and it might be considered like a contract review, like a legal professional would, and that could be considered unauthorized practice of law. So like, don't want to do that. So just always say like, I'm not a lawyer. I'm just looking at it for like content and dates and figuring that stuff out. So that's the first thing I would say. The second thing I would say is just know that you are opening yourself up to a little bit more liability. If you don't catch something, or they say like, oh, well, you should have seen this, you should have done that. It's an added service, but it's also an added liability. Anytime you add another service, there's going to be more liability, right? So make sure you are weighing the cost benefit analysis as you would for anything, right? The next thing I would say is always get everything that you tell them about their contract. I would do it in writing. I would not kind of just relay it over the phone. I would always put it in writing. Or if you do relay it over the phone, just make sure you put in writing in your email, like, hey, this is what we talked about, blah, blah, blah. Some things to look for are dates, refundability, termination, what would happen there, how they have to postpone, the things that you would want to make sure are straight in your contract, you need to look for in other vendors' contracts as well. And then also just kind of looking through for any overage charges, what those are going to look like, because the worst thing would be like your client goes over, or there's damage, or there's extra fees that like you didn't notice, and then you have to tell the client, and then they get kind of upset because they're like, oh, well, you didn't tell us this was going to be an extra fee. And then that kind of falls back on you, and you have to make the decision, well, should I have done that? Should I refund that? Like, should I cover that cost? Like, what is going on? So
yeah, that's also kind of reminded me of COVID. So like what has kind of like changed with the COVID? I think you have a COVID something, right? In your
yeah,
shop?
so all of our templates are updated to include COVID issues. So that's no longer an extra thing, like it comes along with them. But for people who needed the update, and during COVID, when it first hit the fan, we had put out like a COVID clause. So if you have a contract from before, I mean, you're more than welcome to go in and grab that, or like a COVID addendum. But what I recommend is kind of just having it in your contract full time now.
Yes. All right, Caroline. Thank you so much for sitting down with me and going over some of this stuff that I know we've all had questions about.
Yeah.